contact for Taylor Wimpey. I didn't need to pursue that any further, just to let you know in case there's been any questions about that, because I saw sufficiently from the viewpoints I was given. I did then send an email just clarifying the deadline for the unilateral undertaking, which is the 7th of October, assuming that's as agreed. There's no problems there.
Nothing's changed since Thursday, no, sir.
Okay, thank you. And the final point is that I did send a further email just clarifying I had received a drawing showing the measurements of the appeal site from several features, and I did reference that as ID document 5. I'm not sure that really makes any difference now, because unless it's been referred to in the closings. But just to confirm, Mr. Leader, you were copied in on that email, I assume. And
yes, thank you very much, sir.
Yeah, okay, that's fine. Before we go any further, are there any other things I need to be aware of? Any other documents?
Not from our side, no.
And same with me, sir.
Okay, finally, Mr. Banner, have you received Mr. Leader's written closing?
I will just check. I hadn't a moment ago.
Oh dear. I think my email's not working, which is a tad inconvenient. But Mr. Curran was sent it last night before it stopped working, so he can send it to Mr. Banner. I might have twiddled with it, but only to correct typos. So, Mr. Curran, if you're listening, I know you are. Could you possibly send Mr. Banner the closing post haste?
That should arrive in the next few moments.
Thank you very much.
Yes, safely received. Thank you.
Okay,
I had
Mr.
assumed,
Banner,
sir, perhaps improperly, that the case officer might send it on. Sometimes they do. So there we go.
Yeah, okay. Well, that was the other option. I could have asked the case officer to send it on, but I was sometimes there's a preference for it not to be sent until 10 o'clock. So I'm wary of that as well.
When you're as quick as Mr. Banner, sir, it makes no difference.
Okay, well, as long as Mr. Banner has a copy and he's content for Mr. Leader to commence his closing.
I am, yes, sir. Thank you, and I do.
Okay, so it's over to you, Mr. Leader. And just to clarify, I've printed off a copy, so I might be looking down at this, but I'll try and remain engaged. So over to you, Mr. Leader.
Well, thank you very much, sir. The closing should take about 30 minutes to read, no longer than that. And I've set out at the beginning the structure of my closings. I shan't read that out, that would be tedious. Move straight to the main issues. And so I've reformulated them just a little bit. I say the main issues in this appeal are, first of all, whether the appeal proposals would actually or be perceived to cause coalescence between Exeter and Topsham, thereby unacceptably eroding Topsham's separate identity and sense of place. And secondly, whether the harm that is caused by any actual or perceived coalescence that is caused by the appeal proposals is outweighed by its benefits. The council's case in a nutshell is that the scheme would cause coalescence in the sense that the narrow gap that would separate Topsham from Exeter would not be sufficient to impart and maintain their separate identity, and that viewed from the surrounding area, there would be perceived coalescence by the visual merging of the proposed and existing development. That loss of identity constitutes significant and demonstrable harm which is not outweighed by the benefits of the scheme, principally in the form of market and affordable housing, assessed against the policies of the framework as a whole. So then moving on to the development plan, the plan comprises the SAVE policies of the Exeter Local Plan First Review and the adopted Exeter Core Strategy. And the most important development plan policies for the determination of the appeal are policy LS1 of the local plan and CP16 of the core strategy. They bear directly on the question of whether the proposals constitute sustainable development. The other policies cited by Mr. Seaton in his reading of the development plan as a whole are of little materiality. CP1 and 3 merely recalled the plan's housing requirement, and CP7 the contribution that is required to be made by affordable housing. They are not development management policies and have nothing to say about what constitutes sustainable development in Exeter. Local plan policy LS1 restricts development which would harm the city's landscape setting and requires that they maintain local distinctiveness and character. Paragraph 11.8 of the reason justification to the policy indicates those objects include clearly separating the settlements of Exeter and Topsham. Although that text is not saved, it would be absurd to contend a decision maker or a court is not entitled to have regard to it in order to interpret and understand how to apply the policy. Core Strategy CP16 similarly operates to protect and enhance Topsham's local identity by maintaining the city's green infrastructure network insofar as it comprises a strategic gap between it and Exeter. The precise boundaries of the gap are not defined by the plan. The area is illustrated in broad terms on the key diagram. It is common ground. The appeal site is part of the gap. Paragraph 1038 of the policy records the particular importance of the gap as it forms an open break between the two settlements, thus preventing their coalescence. That is clearly its primary object, whilst also protecting Topsham's attractive setting. The words whilst also point to protection of setting being a subsidiary or incidental object of CP16. The Council relies on the primary limb of the policy in its first and only outstanding reason for refusal. As Mr. Banner, King's Counsel, succinctly put it, it all turns on CP16. So then, turning to harm to the strategic gap. Good design is a key aspect of sustainable development. It is realised by a pattern of building which establishes or maintains a strong sense of place. Exeter must continue to grow. To that end, policy CP16 identifies a green infrastructure network which is intended to protect and enhance local identity and provide a sustainable framework for new development as the city expands. As Mr. Cook recognised, this is consistent with the Secretary of State's policy in paragraph 174B of the framework. The core strategy key diagram identifies three strategic allocations. One of those, the new core strategic allocation, is located in the southeast quadrant of Exeter. When it is complete, new development will extend the built-up area of the city to the M5 motorway. The historic village of Topsham is located a short distance to the southeast of Exeter and the new court strategic allocation. There are three main transport corridors between Exeter and Topsham. First of all, the Exeter and Topsham Road, which is an urban route running east-west between Exeter and Topsham. Secondly, Clyst Road, which runs north-west from M5 junction, I beg your pardon, so that runs north-west to M5 junction 30 from the southeast, which is where Topsham is, through the countryside. And three, the railway, which runs from Exeter through Newcourt and Topsham and onto Exmouth. In recent years, Topsham's separate identity has been eroded along each axis. This tendency has been most marked on Topsham and Exeter Road. A continuous line of built development now extends from the city centre to Topsham along the south side of Exeter Road, and new housing development has infilled what was a relatively open area dominated by a sports ground on the north side of that road. Topsham has not been completely absorbed by Exeter. The residual triangular swathe of open agricultural land that lies to the north of Exeter Road, southeast of the new court strategic allocation and southwest of Clyst Road, continues to perform the vital function of buffering Topsham from Exeter and maintaining its distinctive and separate identity. Today, people travelling along Clyst Road from Topsham to Exeter will not see development at the northern edge of Topsham against the backdrop of the city. People enjoying a quiet walk or bicycle ride north out of Topsham along New Court Road and the public rights of way that leak into it will experience a sharp urban edge at the northern boundary of the Taylor-Wimpey side that aligns with ribbon development and recent infill along both sides of New Court Road. And people travelling by train will experience a clear break between Exeter and Topsham some 5 fields deep on crossing the railway bridge over the M5 heading south. This is the land that comprises the Topsham strategic gap. If its function as an open rural buffer is compromised, the maintenance of a green wedge to the east of Clyst Road in East Devon District council area will not preserve Topsham's separate identity. The two settlements will have merged. That fact doubtless explains why the strategic gap continues to be valued by the residents of Topsham for its place-making qualities. Their strongly held sentiment is recorded by Inspector Jill Kingerby in her report on the examination of the core strategy, and more recently, Inspector Jonathan Ball recognised the continuing strongly held local view that the open area between Topsham and M6 and the M5, I beg your pardon, has considerable importance as an open break in development on leaving Exeter and entering Topsham. The value that local people place on the gap really matters. The question of whether new development maintains Topsham's sense of place falls to be judged by the people who live there. It is a people-based psychological construct which reflects their perception, experience and understanding of Topsham's separate identity. Their perception of the erosion of Topsham's identity is similarly important. There is no value at all in a planning system that determines the narrowing of the gap will not harm the separate identity of Topsham if the perception of local people who live in Topsham, experience and understand what it means to live in that place, disagree. That leads to a related point, is that when considering the question of whether Topsham's identity will be preserved if the appeal is allowed, I'm so sorry, so there's a typo there, if the appeal is allowed, consideration should be given to whether coalescence will be perceived to have occurred, as well as whether it has actually occurred by the physical joining up of two separate settlements along the Clyst Road axis. That is not to suggest local people are entitled to construct and maintain place identity capriciously or unreasonably, nor have they or the council behaved in that manner in opposing the appellant's scheme. This is illustrated by the ample, objective and documented evidence that the strategic gap does function to maintain Topsham's separate identity, and I give you there, sir, the references to the Exeter First Local Plan Review, the Exeter Fringes Landscape Sensitivity and Capacity Study, and the Exeter Core Strategy, which illustrate that point. So having established the strategic gap is rooted in notions of good design and sustainable development, which require local identity to be maintained, and secondly, seen that Topsham's identity has been compromised by development along the Exeter Road, and thirdly, identified the value placed by local people on land to the west of Clyst Road and north of Exeter Road, which is I call the Clyst Road Triangle. Fourthly, seen that it is objectively justified, and fifthly, embedded in development plan policy. The fundamental question is, what harm would be caused to its function by the appeal proposals? Starting point is that the impact of the scheme must be viewed against the background of the erosion of the strategic gap by substantial amounts of proposed and consented housing and other urban development post-dating the adoption of the core strategy. And then, so what I do, as you can see, is I compare Mr. Cook's Appendix 9 with LPA 1, which is our plan of recent planning applications in the triangle. Now, sir, I shan't read all of those out because that would just be, frankly, unhelpful use of time. But what I will do is I'll identify the three quadrants I invite you to consider in more detail. They are, first of all, the consolidation of open land to the southwest of New Court Road and north of Exeter Road. And I list there, sir, the three key planning permissions which have infilled that part of the gap. Secondly, I direct you to look at the consolidation of open land northeast of New Court Road and west of the railway. And in addition to the two planning permissions that you see noted at A and B, do note, please, the pressure for further infilling, which is represented by applications detailed for you at C and D. So pressure for more development's a key point. And then thirdly, we have the infilling of land west of Clyst Road and east of the railway, which is the Taylor-Wimpey scheme, to be joined if the appellants succeed by their appeal proposals. So picking up again at 22, the consequence of the steady erosion of the strategic gap is that what remains is more sensitive and more critical to the maintenance of Topsham's identity. And in that context, it is instructive to consider how recent contentious development came to be granted planning permission in the gap. Now, taking Waddington Park's Exeter Road scheme first, that was framed against suburban development on New Court Road to the north and suburban development to the south, and therefore read against the backdrop of existing urban fringe development. The Taylor-Wimpey scheme was judged to erode the strategic gap, but the council considered this would not result in material coalescence. And in each of those appeals, enough openness was judged to remain to avoid harm to the integrity and purposes of the gap. Now, this case merits a different outcome for the following reasons. And I set out, sir, a number of reasons, 6 in total, and I shall read them. The development of the appeal site would extend the built-up area of Topsham north into the strategic gap towards Exeter, first of all. Second, the northern edge of the appeal site extends to within 110 metres of the M5. The M5 to the south of Exeter is an urban feature. It is intended to contain and merges visually with the edge of Exeter at the New Court strategic allocation. At that location, it is not and cannot sensibly be characterised as a transportation corridor that carves its way through open countryside. If I may just add a couple of thoughts there, please, sir. I would invite you to reflect on the fact that to the extent you see the motorway, it is accompanied by considerable amounts of signage, gantries, lights, that sort of thing, which do cause urban clutter. And secondly, it will be read with the buildings that comprise the New Court strategic allocation. It won't be divorced from them. It will merge with them and is intended to merge with them as a barrier. Those are the 2 points I'd ask you to add, please, sir. So moving on to my third point. The extension of the built-up area would reduce what Inspector Ball described as the very important first open land seen after the M5 when travelling towards Topsham, from 5 fields to 1 small field. Fourth, whether a gap of around 110 metres might have been judged sufficient in the particular circumstances of other sites elsewhere in the country is interesting but of little relevance or probative value in the entirely different circumstances of the appeal site. The question of whether a gap is sufficient to protect identity is a highly fact-specific matter and turns on the fine grain of local geography and value-laden perceptions of place. Fifth, turning then to geography, the extension of the, I beg your pardon, so let me read that again. Turning then to geography of the appeal site, its extension of the village north as an uncontained finger of development into the strategic gap is very poorly related to the existing pattern of development. The Taylor-Wimpey site is framed to the east by the development along Highfield Road. To the west, that should be, it is contained by the ribbon of development and infilling on both sides of New Court Road. In comparison, the appeal site is not contained by existing development at all. It merely adjoins the southern edge of Taylor Wimpey and potentially the northern edge of the 30 dwellings sought under application 212694. Viewed from New Court Road, Clyst Road and the railway, the gap is diminished to the extent that the separate identity of Topsham and Exeter would become blurred. And I give you the examples of where that would be so. First of all, views to the west from Clyst Road would provide an unbroken panorama of skyline views of houses on the appeal site and houses in Exeter beyond the motorway. Secondly, views east from New Court Road will be of housing on the appeal site running up to the M5. And third, view from the train, the transit across the gap is so sudden as to render it meaningless if development takes place, I would add there, sir. Quite simply, whereas the Taylor Wimpey scheme might fairly be characterised as rounding off and the Exeter Road scheme as infilling, neither of which harm the function and integrity of the gap, the projection of the appeal scheme deep into the gap has a marked and qualitatively more harmful impact on its function. So, what's the conflict with the development plan? The scheme proposes development in the strategic gap between Topsham and Exeter. That would urbanise land that is presently open and rural. The appeal site abuts what has become the northern edge of Topsham through the development of the Taylor Wimpey site. If it is developed, it would therefore extend built development from the edge of Topsham towards Exeter. That reduction of openness would simultaneously narrow the open break and tend to cause the settlements to coalesce. That would not protect the character and local distinctiveness of the gap, the essence of which is its openness.
Sorry, Mr. Leader, I must stop you there. You have gone silent. I'm not sure if you've pressed something or.
I don't know how that happens, sir.
No, it's okay.
Where did I get to, sir?
So you got to the end of paragraph 25, as Mr. Seaton puts it. I think I got that's as far as I got anyway. I'm not sure whether Mr. Banner. I'm sure he was in a similar position. So I'm content for you to start from there. Mr. Banner's nodded his head as well. So if you can start from, you can either repeat number 20, paragraph 25, or just start towards the end of.
Shall
25.
I start as Mr. Seaton puts it, sir?
Yes. Okay. That'd be great.
It's a bit of a cliffhanger, so I'll start it from there.
Yes. Okay.
As Mr. Seaton puts it, the development would cause what he terms a modest degree of harm, which would arise from its open character becoming less open. It would be wrong to argue that evidence was not concerned with loss of openness. And your note will recall that during re-examination, Mr. Seaton said twice that that paragraph is concerned with the scheme's impact in terms of coalescence and setting, before on the third time of asking, he sought to suggest he did not intend to refer to coalescence. His first two answers are to be preferred, and on that basis, it is impossible to argue sensibly the scheme does not conflict with CP 16. I should add there, sir, that plainly the council does not concur with the assessment of modest harm. The point I make is harm is conceded by the appellant. Finally, in the interest of completeness, the inspector will recall, as you will recall, that Mr. Seaton also sought to argue Inspector Coffey's approach to CP 16 was that if harm is found, that will not necessarily mean there is a failure to protect. That is wrong. Inspector Coffey's decision is concerned with the landscape setting of Exeter, not the issue of coalescence. Further, the inspector concluded the scheme would cause no harm, and I give you the reference in her decision, sir. Consequently, her decision cannot be relied on to support an approach that some harm is consistent with protecting and maintaining the strategic gap in the terms of CP 16. So, other material considerations, housing land supply being the first. Following the recent decision in respect of Spruce Close, the council concedes, and it is agreed, supply of land for housing stands at about 4 years. That is a significant shortfall measured against an important metric. However, it is important to gauge the likely consequence of the state of affairs carefully, to arrive at the correct weighting of the social strand of sustainable development relative to the environmental objections that are raised by the council. The first point to make is that the 5 years housing land requirement, including a buffer, is not an entirely arbitrary target. It's intended to serve certain purposes. They are to secure the continuity of the supply of land for the construction of new homes, so as to ensure choice and competition in the market for land. Where there has been significant under-delivery of housing over the previous 3 years, a 20% buffer must also be added to improve the prospect of achieving the planned supply. Between 2015 and 2019, the council was able to demonstrate less than 3 years' supply of land for housing. As Mr. Seaton agreed, in 2019, the supply was just over 2 years and 1 month. That is a very serious shortfall by any measure. In the 3 years that have passed, the supply has nearly doubled. It is also very important to recognise that in the 3 years of 2021, Exeter achieved a housing delivery test result of 155%. Mr. Seaton properly agreed that's a very strong performance. Of course, the housing delivery test looks at house building through the rear view mirror. However, its value is to provide clear, unequivocal evidence that the severe shortfall of housing land that subsisted in 2019 and the improved supply that has been assembled since then has not prevented house builders providing the homes that people need. And as Mr. Seaton accepted, the requirement to provide a 5% buffer rather than a 20% buffer provides further objective evidence that there has not been, per NPPF paragraph 74C, significant under-delivery over the previous 3 years, nor is it necessary to make that extra provision to improve the prospect of achieving the planned supply. Another consideration is the council's progress with its new local plan. The LDS indicates a draft plan will be published this month, with adoption scheduled for June 2024. That will do 3 important things that impinge on matters canvassed at this inquiry. First, it will deliver a 5 year supply of land. Second, it will wipe out and render entirely academic the question of whether the current requirement can be achieved by 2026. And third, it will guarantee the positive trajectory of housing land supply and delivery in Exeter. Therefore, viewed objectively, whilst 4 years' supply of housing land is not good enough, the evidence is that it has not and probably will not adversely affect the delivery of sustainable development in Exeter. The weight that is afforded to this fact should therefore be tempered where its application would result in harm to the environment. So, moving on next, delivery of market and affordable housing. The delivery of market and affordable housing is usually beneficial, and following the decision in Spruce Close, the council accepts though these benefits should be accorded significant and substantial weight respectively. As for the delivery of public open space and biodiversity net gain, the delivery of open space is required to mitigate the impact of development and make it acceptable in planning terms. The extent of biodiversity net gain that will be achieved remains uncertain. As such, each ought to be accorded neutral weight in the planning balance. And then moving on to employment benefits during the construction phase, the scheme will generate temporary employment benefits consistent with the decision of Inspector Porter at Spruce Close. Mr. Upton attributes them moderate weight. So coming to the planning balance, the scheme conflicts with the anti-coalescence objects of policy LS1. Critically, it also conflicts with the anti-coalescence provisions of policy CP16. On the ground, Topsham would be perceived to coalesce with Exeter from certain perspectives in the local landscape. Its physical extent would be reduced to such an extent that to all practical intents and purposes, it would cease to operate as a meaningful buffer between the two settlements. NPPF compliant development plans, such as the core strategy, describe what constitutes sustainable development at the local level. They embody the aims, aspirations, and objectives of local people. The scheme's conflict with the development plan matters to them in a practical as well as a legal and technical sense. If they continue to be disappointed by decisions that allow the erosion of the gap, in this case the point that would become a single field at its narrowest point, that is liable to undermine their confidence in the planning system to deliver sustainable development in their area. Therefore, in this case, the statutory presumption that the appeal should be dismissed ought not to be displaced without good reasons being shown, and there is no good reason to allow this appeal. In making that assertion, it must be acknowledged that the Council's housing land supply position has the effect that the policies which are most important for the determination of the appeal should be considered out of date, and accordingly it's necessary to weigh the conflict with the development plan against other material considerations, including the presumption in favour of sustainable development. And for the reasons that have been given, the delivery of market and affordable housing are benefits which carry significant substantial weight in favour of allowing the appeal. The scheme's economic benefits carry moderate weight. However, consideration of the full range of housing land supply metrics indicates it is unnecessary to allow the appeal to boost housing delivery or to improve the prospect of achieving the planned supply of land to build them on. Viewed in that context, the adverse environmental impact of the scheme on Topsham's identity on the ground and as perceived by local people would significantly and demonstrably outweigh its economic and social benefits. The enhancement of green infrastructure and good design, which maintains local identity, lie at the heart of sustainable development. That will not be delivered by this scheme, which is clearly unsustainable, and therefore, sir, you're respectfully invited to dismiss the appeal. Unless I can assist you further, sir, those are my submissions.
No, thank you, Mr. Leader. I have made the notes of corrections as well.
Yes, sir, I'm sorry about that. I'm beginning to wonder whether I've sent you the unedited version. However, it doesn't matter, sir. I hope that you've been able to make those corrections without difficulty. If you haven't, sir, do direct me to the relevant parts and I'll do it again. No,
that's fine, Mr. Leader. There were relatively minor typos or other corrections, so I have made those as we've gone through, and there was no need necessarily to submit the closings in writing anyway, so I do appreciate that. So I'm happy to accept the written closing and the amendments I've made. Mr. Banner, would you like a break?
No, I'm ready to go. I've sent mine to I think you will have them already, and Mr. Leader and Mr. Cohen have already got them as well.
So
Thank
Mr.
you
Leader,
very much.
No, so just check, Mr. Leader, you have a copy of Mr. Banner's closing.
Well, I'm afraid I don't, sir, because my email's not working. But if I may say this, I'm not allowed to respond to Mr. Banner, who gets the last word. And I doubt we're having any detailed submissions on law. So on that basis, I'm happy to proceed. And if for any reason we need to have further conversations, well, I'll have to try and work out a way of doing that. But I can't receive an email at the moment, so something's happened to Chambers' system.
Okay, but you're happy to proceed?
Of course, sir.
Okay,
yes.
that's fine. So, Mr. Banner, just bear with me a second while I get the written version on my screen. Apologies.
That's okay.
And I shall follow Mr. Banner's practice of disappearing while submissions are taking place.
Okay, Mr. Banner. So just your closing's on the other screen, so I might be looking to my left, but
that's okay.
I'm not looking out the window, just to make that clear. I will be looking at your submission. Okay, Mr. Banner, over to you.
Thank you, sir. So by way of introduction, first of all, given the various concessions made by the council, the issues in this appeal are actually now relatively straightforward. It's now common ground that, amongst other things, the council can't demonstrate a 5-year supply, the shortfall being around 683 units, a supply of around 4 years, which is more than a modest shortfall. The tilted balance therefore applies. The current evidence indicates that the at least 12,000 minimum housing requirement figure of the core strategy won't be met over the planned period. It's also agreed that significant weight should be given to the appeal scheme's delivery of the 65 market housing units, and that substantial weight should be given to the scheme's delivery of 35 affordable units. It's also agreed that the effect of the tilted balance is that permission should be granted unless the adverse impacts of granting permission significantly and demonstrably outweigh the combined force of these two significant and substantial benefits, plus the other benefits of the appeal scheme. This starkly contrasts with the basis on which the application was assessed in the officer's report, and thus determined, which proceeded on the basis that there was a 5-year supply and that the tilted balance didn't apply, describing this as a notable shift and distinguishing the decisions of Inspectors Bore and Hetherington on this basis. Even then, the officer's report opined the decision to refuse was a balanced one, which Mr. Upton accepted should be taken to mean on balance. It's also agreed that the lack of that 5-year supply means that under the framework, paragraph 11D, the most important policies in the development plan, including LS1 and CP16, are deemed out of date and carry reduced weight as a result. As for Save Policy LS1, it's agreed also that this is out of date and can't sustain refusal on its own. The Council's opposition to the appeal turns on policy CP16. The objectives of that policy, CP16, in relation to the Topsham gap are those set out at paragraph 10.38 of the core strategy, namely preventing the coalescence of Topsham and Exeter and protecting Topsham's attractive setting. It's agreed that the appeal scheme doesn't lie within Topsham's attractive setting for this purpose and doesn't harm it. That limb of para 10.38 isn't relied upon. The appeals site is not a valued landscape. That too is agreed for the purposes of MPPF paragraph 174A, and it has low intrinsic landscape value. Consequently, the Council doesn't rely upon landscape and visual harm per se in its opposition to the appeal. And as Mr. Cook noted in his proof, the site is framed by built infrastructure, including the Taylor-Wimpey scheme, the railway and the pylons. The Council's sole objection is an allegation of coalescence. This objection is immediately put into context, however, by the Council's acceptance at the inquiry that, contrary to what was implied in Ms. Priscott's written evidence, the site is not the last field between Topsham and Exeter in this vicinity, and there will still be a post-development green gap of circa 125 metres, 110 metres, so Ms. Priscott measured to the motorway, plus the boundary trees and landscaping. Plus, there would be the motorway between the edge of Topsham and the edge of Exeter. The Council acknowledges that making up the housing supply deficit, which it accepts it must strive to do, will necessitate the release for housing of unallocated greenfield sites, which are covered by policies CP16 and LS1, and which will involve conflicts with those policies. And importantly, the Council also accepts that the observations of Inspector Hetherington at paragraph 43 of his decision remain good, namely that such land identified in the Exeter Fringes study as being of medium landscape sensitivity, including the appeal site, must come into consideration for further housing, and that as such, some adverse impacts on such land would be unavoidable. The appeal site in the present case, like that in the case before Inspector Hetherington, is in EFS Zone 21, one of the few zones identified as being of medium sensitivity. Mr. Seaton's observation and evidence in chief that zones 21 and 22 are the only remaining medium areas that haven't already been developed wasn't challenged and must therefore be taken to be accepted. The Council has, sir, no answer to the question, if not here, then where? And consistently with the foregoing point, the Regulation 18 version of the Council's emerging new local plan is postulating no fewer than 4 allocations in the Topsham gap, all of which are on parcels the landscape sensitivity of which is identified by that emerging plan as medium, the same as the appeal site. Against the backdrop of these agreed points, the case for allowing the appeal is truly compelling, irrespective of whether there is or isn't compliance with CP16 and or accordance with the plan as a whole. The scheme will make a vital and urgently needed contribution to meeting market and affordable housing needs which aren't currently being provided for, and it will do so without harm to Topsham's attractive setting, without any objectionable landscape and visual impact or any other alleged harm, save beyond the coalescence objection, and on land identified in the EFS and the emerging new plan as medium sensitivity, which is a category the Council accepts must come into consideration for release for housing. In other words, it delivers 100 units, and what in light of what the Council has now agreed is about the lowest level of impact possible for a CP16 LS1 site, and we know such sites have to come forward. In these circumstances, any adverse impacts of granting permission do not come remotely close to significantly and demonstrably outweighing the benefits. Set against that overview, we now turn in more detail to the main subject of discussion in the evidence at the inquiry. I'll start with the main benefits, market housing. The attempt by Mr. Leader in cross-examination of Mr. Seaton and just now in closing to downplay the seriousness of the Council's housing shortfall goes nowhere, given that the council accepts significant weight should be given to the delivery of market housing in light of the shortfall. It is important, however, to appreciate just how serious the situation is. There are two strands to the shortfall. First, there's the shortfall of about a year, 683 homes, in the context of the 5-year supply assessment under the framework. Inspector Porter in the Spruce Close appeal rejected the council's suggestion the shortfall was only modest. This isn't a temporary blip, quite the opposite. In January 2019, Inspector Hetherington noted that the council's then sub-5-year supply dated back to at least 2010. The housing delivery test is backward-looking. It tells one nothing about future supply. The framework is clear that LPAs must have both a 5-year supply and pass the HDT. One isn't a substitute for the other. References to the council's recent HDT performance therefore don't affect how one should view the shortfall in 5-year supply. Besides, the 2021 HDT requirement was reduced by 4 months due to the pandemic, so the 155% score figure. Secondly, the evidence is clear that the council will undershoot by a considerable margin the minimum requirement figure for the core strategy plan in policy CP1 of at least 12,000. As noted in opening, this was itself a constrained figure, and it remains the extant target over the plan period. Mr. Upton rightly accepted in cross-examination that the observations of Inspector Boniface in this respect and the recent Soham decision are applicable here. As is in that case, the CP1 requirement remains part of the development plan for the purpose of section 38.6 and is an important indication of whether the core strategy is effective in significantly boosting the supply of housing as is called for by the framework. Because it can no longer be said that sufficient housing sites will come forward to deliver the requirement figure on allocations and within the settlement boundary, and instead some unallocated CP16 LS1 land needs to be released and some conflicts with them tolerated, CP1 and CP16 LS1 pull in different directions. This means it would be possible in principle to find that a development which has some conflict with CP16 and LS1, but which would help address the CP1 shortfall would be in accordance with the plan as a whole. Inspector Boniface reached a similar conclusion in the Soham case. So for these reasons, real significant weight should be given conscientiously and in substance to the contribution that the appeal scheme would make to housing delivery. Mere lip service won't do. And the same can be said about the substantial weight which the council accepts must be given to the delivery of 35 affordable homes. Mr. Seaton's evidence on affordable housing wasn't challenged in cross-examination or contradicted in the council's evidence. It must therefore be taken to be common ground. I invite you to reread it. The picture it portrays is deeply troubling and ever worsening affordable housing supply crisis, with an average delivery of 94 units a year against the constrained core strategy objective of 215 a year and the actual identified need of 325. Just 6 affordable homes, less than 2% of the annual identified need, were delivered last year. A truly shocking situation. Inspector Porter was right to describe it as one of demonstrably acute and persistent under-delivery. The cumulative shortfall against identified need currently stands at an astonishing 2,134 dwellings. In terms of other matters, there's no current legal or policy requirement for any particular percentage net gain. This may change in future. The council's according of neutral weight to the ecological enhancements on the false premise that this is no more than is currently required. The appellant's description of moderate weight should be preferred. That Parliament has decided to legislate for 10% net gain to be required in future makes untenable Mr. Upton's suggestion that 10% shouldn't be seen as particularly meaningful. And it's agreed that economic employment benefits should attract moderate weight. So, sir, the combined weight of all these benefits sets the bar for the council's objection to significantly demonstrably outweigh, and it is a high bar indeed. I turn then to policy CP16 and alleged coalescence. Let's start with the applicable test. There's confusion within the council inquiry team as to what policy CP16 requires. Mr. Upton accepted in cross-examination that the acid test of compliance with CP16 in the context of the Topsham gap is whether development would cause a significant adverse impact on either or both of the paragraph 1038 considerations. Interpreted thus, as the appellant says it should be, CP16 isn't a rigid zero harm policy, but has a degree of built-in tolerance or flexibility. Inconsistently with this, however, both Mr. Upton and Ms. Prescott nonetheless appeared to consider that any significant development in the gap would breach CP16. Mr. Leader suggested a different test, namely that adopted by Inspector Hetherington, whether there would be material as opposed to significant harm to the paragraph 1038 objectives. Mr. Seaton, in his evidence, explains that the interpretation of CP16 as having a degree of built-in tolerance or flexibility in the way I've described above is consistent with how the core strategy examining inspector Jill Kingerby saw the policy performing, as well as consistent with appeal decisions by Inspectors Webb and Coffey, the latter of which was endorsed by the High Court. Mr. Seaton further explained in his oral evidence that another way of looking at this was to remember that CP16 has to be considered in the context of the plan as a whole. If one takes the rigid no material harm to the 1038 objectives approach to CP16 viewed in isolation, that is likely to mean more conflicts with CP16 are going to be necessary to deliver the CP1 requirement figure than if CP16 is interpreted as having a degree of tolerance or flexibility. In that situation, a technical or limited breach of CP16 plainly doesn't preclude a finding that there is nonetheless accordance with the plan as a whole. Does the scheme cause coalescence? Well, in cross-examination, Ms. Prescott agreed, that the key litmus test in considering whether there would be coalescence is whether Topsham and Exeter would become or be perceived as one single settlement, and whether their separate identities would be preserved. The main aspects that contribute to Topsham's separate identity were correctly found by Inspector Bohr in the Exeter Road appeal to be its history, its old buildings, its streets, its waterside setting and community spirit. And as Ms. Prescott agreed in cross-examination, none of those would be affected in any way by the appeal scheme. The site lies on the edge of the modern fringe of Topsham that has over time developed away from the origins of the port. As already noted, it's also agreed not to be within what paragraph 1038 refers to as Topsham's attractive setting, in contrast to the selection of photographs in Mr. Cook's Appendix 17. It's also the case that the M5 provides a very strong boundary between Topsham and Exeter. Ms. Prescott rightly accepted in cross-examination that policy CP16 and its supporting text is directed at Topsham and Exeter, not Topsham and M5. She also rightly accepted that the M5 lies between the two. Her measurement of 125 metres as being the distance between the M5 and the built edge of the appeal scheme does not indicate the full degree of separation there would be between the edge of Topsham in this part and the nearest edge of Exeter on the other side of the motorway. Mr. Cook's ID5 demonstrates this would in fact be very considerably more than 125 metres. Notably, however, even 125 metres is greater than the 120 metre distance, which Inspector Martin Whitehead found would maintain a sufficient break between the historic settlement of Ernley and the modern suburban edge of Bracklesham in the recent Clappers Lane decision. And that was in the context of two settlement edges being visible from each other, which resulted in greater vulnerability to perceived coalescence than in the present case, where due to the M5, there's no intervisibility at all between the edge of Topsham and the edge of Exeter. The appeal decisions in both the Exeter Road and the Taylor Wimpey site found no coalescence on those sites, which were respectively nearby and adjacent to the appeal scheme. The latter decision, the point wasn't discussed in any detail by Inspector Hetherington, as the council accepted the development wouldn't contribute to coalescence, in stark position for the present case on the adjacent site, when its entire case is based on coalescence being a showstopper on its own, even in the context of the tilted balance. In the Exeter Road case, Inspector Bohr's critical finding in this respect was enough openness would remain to provide a more than adequate appreciation of leaving one settlement before entering another. And he also noted the first open land after the M5 towards Topsham is and will be very important in maintaining the separate character of the two settlements. In the vicinity of the appeal site too, the first open land immediately after the M5 will remain open if the appeal scheme were to be developed. The open land that will remain in this facility, as noted above, 125 metres at its narrowest, but it extends out to a considerably broader degree along the Clyst Road, the yellow highlighted area on the marked up plan I circulated during the inquiry. This is the area described by Ms. Prescott in her consultation response as the key land in maintaining the rural hinterland and the perception of the gap. In cross-examination, she accepted her proof of evidence was inconsistent with this previously expressed view, and she conceded she had in this respect beefed up her analysis following the council's reasons for refusal. Her consultation response was right, and her subsequent revisionism should be rejected. As Mr. Cook explained in his oral evidence, whichever way one looks over this land, one wouldn't see the appeal scheme and Exeter in conjunction, and the break between the settlements would prevail. This will also be the case for passengers on the train who happen to be looking out of the window and concentrating hard enough on the scenery. The sense of leaving one settlement and arriving in another will remain. For those in the train service, this change is currently swift but noticeable, and it will remain such. Also relevant is the extent to which the development will be visually contained. In cross-examination, Ms. Priscott ultimately conceded that Mr. Cook's Section 8 and Appendix 15 were correct in this regard, save for her qualification regarding fleeting views, which she preferred to describe as glimpsed. Mr. Cook also explained in his evidence that the thickness of the existing hedgerows means that they won't be permeable to views in winter. His Glivia 3-based visual impact analysis in Appendix 6 of his proof was the only such analysis before the inquiry and is plainly sound. The extent of visual containment is relevant to coalescence as it further reinforces the conclusion that the appeal scheme wouldn't contribute to perceived coalescence. Note also that Mr. Cook's evidence about the factors relevant to sensitivity and the effect or not of the appeal scheme on them at paragraphs 3.6 and following of his proof wasn't challenged in cross-examination. Pulling all this together, in short, if the appeal scheme goes ahead, Topsham and Exeter won't physically merge. The factors most relevant to preserving Topsham's separate identity from Exeter would be unaffected. Topsham wouldn't appear closer from any vantage point in Exeter and vice versa, there being no intervisibility due to the M5. A green gap would still remain between the M5 and settlement edge. The sense of leaving one settlement and arriving in another will remain. The appeal scheme therefore won't contribute to actual perceived coalescence. If contrary to that, you disagree and you were to identify conflict with CP16, what weight does that attach? Well, in that situation, we rely on Mr. Upton's concession in cross-examination very fairly that the following considerations are relevant to weight. The fact that, as a most important policy, CP16 is out of date due to the 5-year supply shortfall. The extent of any conflict, the more limited it is, the more limited the weight, and vice versa. The fact that making up the housing supply deficit, which the council accepts it must do, will necessitate the release for housing of unallocated greenfield sites, which are covered by policies CP16 and LS1, and which will involve conflicts with these policies. And the fact that the observations of Inspector Hetherington in paragraph 43 of his decision apply here too, namely, and I won't quote it because I have already, but that medium land in the EFS must be considered for housing. Individually and in combination, these factors significantly reduce the weight that should be attached to a conflict with CP16 should you find such a conflict to exist. Putting all this together in conclusion, our primary case is that the appeal scheme is in accordance with the development plan, either because it's in compliance with CP16, which prevails over LS1 by virtue of section 38.5, or because any conflict with CP16 is modest and outweighed by the contribution the scheme would make to addressing the shortfall in the delivery of the CP1 housing requirement figure, the delivery of which will necessitate some unallocated development on CP16 land, meaning that there is accordance with the plan as a whole, as there was in the Soham case, for similar reasons. Accordingly, if you agree with us on that, then paragraph 11C of the framework applies. The scheme should be approved without delay. The council doesn't suggest that there are any material considerations which indicate that the permission should be refused in the event of a finding of accordance with the plan. Alternatively, if you were to find there's non-accordance with the development plan as a whole, then paragraph 11D of the framework applies, in particular the tilted balance in 11D2. Any adverse impacts of granting permission don't significantly demonstrably outweigh the compelling benefits of doing so. Whichever way one looks at this case, therefore, the proper planning balance unquestionably comes down in favour of the conclusion the appeal scheme is in the public interest and should be allowed to proceed. So for those reasons, sir, we invite you to allow the appeal, and thank you for holding the inquiry.
Thank you, Mr. Banner. Mr. Leader, just to check, you did hear all the closing submission by Mr. Banner.
Yes, sir, I did. Thank you very much.
Okay, that's fine, and you should receive a written copy as soon as your emails are back up and
Well,
running.
funnily
Thanks,
enough,
Ian.
sir, shortly after Mr. Banner started, I reloaded my email and it works. So I have it. Thank you very much.
Okay, that's great. Thank you. Okay, so that does conclude the inquiry. I will make 2 final calls. So anything else, you've already said there's no other documentation, and I will take that as read, but just I am double checking, triple checking that is the case. This is the last chance to say anything about the appeal before I do close the inquiry.
No, thank you, sir.
No, thank you, sir.
And I have asked at least twice prior to this, but I will ask again, applications from either main party. So Mr. Banner.
Not from me, no, sir. I should say at the very end of my closing, there's an annex on the probate issue. I haven't read that out because it's fairly dry, but it's on the final 2 pages. But no cost application, sir.
Okay, thank you. No, I have just noticed that, so thank you for pointing that out. Mr. Leader, costs, any cost application?
Not from me, sir. Thank you.
Okay. Well, that was thank you for going through your closings very swiftly and for submitting them to me. So as far as I'm concerned, that's the conclusion of the inquiry. There's nothing else to cover. I have done the site visit and we've covered quite a lot of material over the last few days. Just thank you for your patience as well, given the unfortunate opening, the delay by by 24 hours. So thank you for your patience on that. And the time is coming up to 11 o'clock. So I am now going to close the inquiry. And I wish you both a nice remaining, the afternoon you've got free now. So hopefully you have a nice,
Thank you, sir.
Nice
Thank
day.
you, sir.
So thank you. The inquiry is now
Have a good
closed.
day. But goodbye.
Thank you then. Bye.